Welcome to Rock Center Shorts. I'm Kristen Savell, Co-Executive Director at the Rock Center for Corporate Governance at Stanford. My guest today is Patrick Stokes, a litigation partner in Gibson, Dunn & Crutcher's Washington, D.C. office. Patrick is co-chair of the Anti-Corruption and FCPA Practice Group and a member of the firm's white-collar defense and investigations, securities enforcement, and litigation practice groups. Before joining Gibson Dunn, Patrick spent nearly 18 years with the U.S. Department of Justice, most recently heading the FCPA unit, and prior to that, serving as co-chief of the DOJ's Securities and Financial Fraud Unit. Earlier, Patrick served as an assistant United States attorney in the Eastern District of Virginia. Welcome, Patrick.
Thank you, Kristen.
Today, we're going to talk about the Foreign Extortion Prevention Act, or FIPA for short, which President Biden signed into law on December 22nd, 2023, and what FIPA means for U.S. companies. To start things off, Patrick, would you walk us through the key aspects of FIPA and why it matters for the anti-corruption community?
Sure. So FIPA, as you said, new statute signed in December, is maybe an easy way to think about it. It is a parallel statute to the FCPA permitting prosecution of the foreign officials who the FCPA does not cover. The FCPA statute in the US covers the bribe payers, the supply side of the bribe, and FIPA applies to the bribe recipient, the government official, or the demand side of that equation. And so FIPA it's included in a separate statute. It doesn't amend or change the scope or the focus of the FCPA. And under this new provision to a domestic corruption statute, it applies to foreign officials defined somewhat differently than in the FCPA, but similar. It applies to foreign officials asking for, demanding, or receiving bribes from the same categories, what appears to be the same categories of bribe givers that the FCPA covers: issuers, domestic concerns, as well as people operating within the United States at the time of a payment of a bribe or operation of a bribe scheme.
All right, so you noticed a slight difference in the definition of government official. Are there other notable differences between FIPA and the FCPA?
Yeah, so let me touch just briefly on foreign official, and then I can talk about some of the other distinctions. But the definition of foreign official is drafted differently in this statute than in the FCPA. But I think the expectation is that as a practical matter, it will be very similar to the scope of foreign official that's covered by the that is identified within the FCPA. It applies to government officials that would be not fully defined in the statute, but likely we expect that it would cover employees of state-owned enterprises as well as politicians and ministers. The statute defines foreign official to also apply to government officials who have not yet been installed in place in their government position. So presumably that would mean politicians who've been elected but haven't, been sworn in yet. Perhaps government ministers who've been selected but haven't been, who aren't in position yet. And so it seems to expand, at least definitionally, the group of foreign officials that might apply, although it's a fairly marginal group or narrow area that it expands it to. Other areas, and this will be examined by courts, presumably, and these definitions will be, pressure tested by judges and defined more clearly. FIPA only applies to the foreign officials. It does not apply to the bribe payer. So if there's a prosecution of a foreign official, presumably that would be done under FIPA going forward. If there's a prosecution of the bribe payer, presumably that would be done under the FCPA going forward.
Even before FIPA, foreign officials who accepted bribes could be subject to prosecution by the DOJ, correct?
Yeah, that's exactly right. So under the FCPA itself does not apply the criminal statute or criminal penalties to the foreign official, him or herself. That said, and that's by statute, the words of the statutes, the FCPA statutes themselves. However, prosecutors have long used money laundering laws, anti-money laundering laws, as well as wire fraud or other offenses in order to go after foreign officials who may be taking bribes. And so as a result, it's not entirely clear whether FIPA, as a practical matter, really expands the toolkit that prosecutors have available to them in a substantive or meaningful way. Prosecutors have, for a number of years, already been prosecuting foreign officials in connection with FCPA cases. So employees of state-owned enterprises, particularly those who've left state-owned enterprises and come to the United States, either traveling in the United States or now residing in the United States. And the US has been going after officials, for example, at the Venezuelan state-owned oil company. There have been a number of prosecutions over the years of former employees who are under the FCPA, foreign officials. They've been prosecuted for money laundering, wire fraud, or other offenses.
Great. I want to spend most of our time today talking about how FIPA impacts US companies. So let's start at the beginning of a bribe cycle and we can work our way to the end. If a foreign official makes a bribe demand to a US company, can the company use FIPA as a shield to avoid paying the bribe? Because now the company can say, well, not only is it illegal for me to offer you a bribe, but it's illegal for you to accept a bribe. So we should probably avoid going down this path.
That's right. In theory, it provides companies in market where there are bribe solicitations the ability to say, FYI, you could be prosecuted in the United States for this. Perhaps a delicate conversation for a company to have with a foreign official, but nonetheless provides, something more concrete for private parties to point government officials to. Again, those same foreign officials could be prosecuted for that conduct in the United States, at least in theory, under money laundering or wire fraud laws, as the law existed prior to FIPA. But the fact of FIPA, which explicitly applies in the bribery context to officials, provides something clear for companies to point to.
If a company is subject to a bribe attempt by a foreign government official, should the company report it? And if so, would that report be made to the DOJ or to a US embassy?
Yeah. So the US government would say, absolutely, you should report it. I think that practitioners on the defense side, as well as companies, may reach different conclusions. First, it's not mandatory. There's no mandatory reporting requirement for a company. If the company discloses this to the US authorities, generally speaking, DOJ would want that disclosure to be to DOJ, and likely, as it does with the FCPA, would not consider a disclosure to some other government agency as a legitimate self-disclosure of misconduct. In fact, they might even view that as a way of trying to get credit for disclosure without actually bringing it to the attention of the Department of Justice, which would trigger an investigation. So the DOJ has been very clear. A self-disclosure requires a disclosure to the FCPA unit. We anticipate that the FCPA unit will also handle FIPA cases, and we expect that they would, make clear that their expectations is the disclosures would come to DOJ. Companies aren't required to do so. DOJ certainly will try to encourage companies to do that. But, there are a host of thorny issues that companies will have to assess in whether to disclose such conduct. Because at the time of company discovering that a foreign official has solicited bribes, the company may legitimately and appropriately want to better understand, well, what's our history with this government official or this agency? Do we have risks from past conduct? And how might this impact the company? And so companies often, understandably, want to investigate these issues to better understand the risks as it applies to the company and its shareholders before going into the Department of Justice. The Department of Justice and the SEC have pushed very hard to shorten that time period to nearly immediately that companies should bring it to their attention. That's what DOJ has been pushing for, and the SEC as well. Companies and counsel often like to have a better sense of what the conduct actually is before they walk it into the government or decide whether they should walk it into the government. I should also just, I mentioned the SEC, I should be very clear here. FIPA it's a criminal statute that the DOJ will be able to use. It's not a statute that's available to the SEC at this stage. It's not a securities related offense, which is what the SEC handles, and the FCPA itself is a securities related offense, but FIPA, isn't covered, isn't something that the SEC will be able to use.
Got it. So another distinction there between FIPA and the FCPA.
That's right.
All right. So if a foreign government official makes a bribe demand and the company pays it, are there situations where the company could use FIPA to either avoid prosecution or seek a better resolution?
Sure. So DOJ has been very clear, and the SEC, that disclosures and cooperation are ways of gaining credit. DOJ in particular has put out guidance, memos, what have you, that self-disclosures and cooperation, remediation, and investigations make it more likely that a company could get a declination. DOJ hasn't put out guidance yet on FIPA, but I wouldn't be surprised. Certainly when I was running the FCPA unit, we would have done this. I would expect that DOJ will incorporate this into the guidance that it has on the FCPA and prosecutions of the FCPA, and would signal to companies that to the extent that they're identifying misconduct by not only their own employees, but government officials, that will, that can certainly benefit them and lead to declinations. But it certainly isn't a defense to an FCPA violation. It isn't, necessarily going to lead to the government agreeing to a declination. But certainly, the more cooperative the company is, the more information they're sharing about other parties engaged in the bribery, and the more sort of actionable evidence a company is bringing to the department's attention, the more likely the company is the more benefit the company may get from that information that it gives to the department. But recognizing that bringing actionable information to the government's attention is bringing actionable information to the government's attention that can be used against the company, not just the official.
All right, so it sounds like FIPA has the potential to benefit some companies if they can use it to avoid paying a bribe or potentially to secure some cooperation credit if they do pay a bribe. But on the flip side, I'm wondering whether FIPA could actually create additional risk for companies. For example, I wonder if FIPA could create a new avenue for the government to prosecute companies for conduct not currently covered by the FCPA, something like a conspiracy to violate FIPA charge or something along those lines.
Yeah, well, so unclear. I think that's going to be up to courts to decide the scope of FIPA. It seems a risk for the government pursuing a FIPA case against a company that's paying the bribe is that the court could interpret FIPA to only apply to the government officials, and because companies or the bribe payers are excluded from the statute, courts may very well use a line of reasoning they've used in the FCPA to exclude parties from accessory liability, like aiding and abetting and conspiracy. So the excluding bribe payers from the category of defendants or targets under the statute, whether it's direct liability under the statute or conspiracy or aiding and abetting. That said, as a practical matter, those companies presumably would already be prosecutable under the FCPA. And so the penalties of the FCPA can already be applied to those companies or the employees or third parties. And the FIPA statute then could be used in parallel with the officials. Again, how much that's changing the playing field now is, is really an open question, because the government can already do that with money laundering and wire fraud statutes, in terms of going after government officials.
Mhm. I could also envision corrupt officials who are investigated under FIPA telling US authorities about all the bribes they have received in order to obtain cooperation credit. And now those bribe payers, some of which might be US companies, could be subject to FCPA prosecution. Does that seem like an additional risk that companies should be considering?
Theoretical risk, yes. And what I mean by that is, again, government officials can already be prosecuted under money laundering and wire fraud and other statutes. And so if the US government prosecutes a government official, gets that official in the US, and the official decides to plead guilty and cooperate, or is convicted at trial, in theory, the government official can provide that type of information as a way of getting a lesser sentence, or perhaps minimizing the impact of the prosecution in other ways, whether through, some sort of deferred individual agreement, or just a lesser offense. So, the government does that all the time in federal criminal cases with drugs, bribery, wire fraud, what have you. It has cooperators. Well, a government official could be a cooperator now, or, pre-FIPA, just as they can be a cooperator post-FIPA, and get benefit from that. And so the government could derive information from officials. I think the big difference with FIPA remains to be seen is two things. One is, are officials now going to be more aware of the fact that they have exposure in the United States under FIPA? Because most foreign officials aren't going to know what the jurisdictional requirements of US money laundering laws. And so they're not going to be thinking about that probably as it applies to them. But FIPA directly applies to them, and there's a lot of press about it. And so foreign officials may be more cognizant of the fact that they have exposure in the US. And then just how will DOJ use this? Will they use FIPA in the same ways they're already using the money laundering laws, which is to say DOJ is not actually is going after a category of foreign official, but not broadly going after foreign officials because of the diplomatic and sort of thorny foreign policy issues that surround prosecution of foreign government officials. And so is FIPA going to change that? Will DOJ decide, because of pressure from Congress or pressure from politicals in the executive branch, to more aggressively go after foreign officials as a result of having this arguably new tool?
What do you see as the long-term impact of FIPA? Are more foreign officials prosecuted? Do bribe demands on US companies decline? Do you think FIPA will help even the playing field for US companies that have long been prohibited from paying bribes to foreign officials, even though their counterparts in other jurisdictions may not be subject to similar restrictions? Or is there very little change because we already had these money laundering laws that could be used to prosecute foreign government officials?
I think it's too early to tell, but I think the change, if there is change, is going to be gradual. And I think the change, what we're looking for is to see, is DOJ, so the category of foreign officials that the DOJ is currently going after tends to be employees of state-owned enterprises. In many instances, they're employees of state-owned enterprises who have left and are now in the United States, or now are no longer with the state-owned enterprise, or high level. And they tend to be employees of state-owned enterprises at countries that are disfavored by the US, Venezuela, for example, or countries where the US isn't as concerned about the diplomatic impact of a prosecution. The category that the DOJ hasn't been going aggressively after are sitting politicians and sitting ministers, understandably, as well as even former government officials. They have now, more and more in Latin America, we've seen, go after former politicians, just as the local foreign countries have done themselves. And so I think the question is DOJ going to become more actively involved in prosecuting these other categories, sitting officials, I think it's unlikely we're going to see anytime soon that DOJ is going to prosecute a sitting politician in, in France or in Singapore or in Brazil, right? I think that could be destabilizing and could have significant diplomatic blowback, and DOJ is not trying to create a diplomatic war. But there will be pressure on DOJ to report out to Congress as required under FIPA, and there may be higher level DOJ pressure on the FCPA unit to bring these cases. So it'll be interesting to see whether there is a sea change in how countries view the prosecution of corrupt officials, such that over time there's more tolerance of, sitting government officials who are asking for bribes or extorting money from companies, that DOJ will start to go after them more aggressively. But I think that's going to be a very gradual change over time, that DOJ is going to see kind of how foreign governments are reacting, and get a better sense of how the tool can be used.
Right. Last question for you, Patrick. Are there steps that U.S. companies should be taking now in light of FIPA's passage, particularly those companies that are operating in high-risk areas?
Yeah. So, most companies should already have in place compliance policies and procedures that are addressing their anti-corruption risks in, overseas, on a risk-based basis. FIPA does not significantly change the type of exposure that a company is facing. In fact, it doesn't apply to the companies, it applies to the foreign officials themselves. The FCPA itself that applies to the companies hasn't changed. So companies' compliance policies and procedures should already address the risk area. That said, this is a new development, and while it may not necessarily provide an avenue of prosecution that didn't exist before, it is going to give more prominence to this issue, and it's going to be unclear for some time whether it will lead to broader investigative efforts against foreign officials, whether it could lead to more self-disclosures, whether it could lead to more companies getting pulled into DOJ investigations from foreign officials being prosecuted. So I think it would be prudent of companies to incorporate the fact of this statute and the application of the statute to foreign officials in their policies, and in training, but it's not going to dramatically change the procedures companies use for third-party, diligence, for example, or for monitoring. But certainly making their employees aware of this new statute in the U.S. would be prudent. If for no other reason than what you described at the outset, Kristen, could companies use it as a basis to saying to foreign officials, hey, sorry, I can't pay a bribe. That's not only is it a problem for me, but it's a problem for you. And that's a helpful, that could be a helpful tool for companies. And so making their employees aware that of this expansion, may have some benefit.
Right. Thanks so much for joining us today, Patrick. And thanks to the audience for tuning in. I will see you next time.
Thank you very much, Kristen.
Great to have you.